Yes, sir.
I discussed the state's offer with our client who rejected it, and we're announcing ready for trial. What's in the Lewis? Should be bottom of the second page.
The second page? Yeah, okay. Let me see Lewis's final page. At the bottom. Where is he?
He's sitting here in the courtroom, Judge. Would you like him up here?
Yeah. Yes, please. You're Milton Lee Lewis?
Yes.
What is your address, sir?
2350.
Speak up.
2350 Fillmore.
I hear 2350
Fillmore.
here in Beaumont.
Yes, sir.
What's the zip code there?
Think 03.
You think 03? I never say I think my zip code is blank.
Think 03.
How do you spell that street? FPH?
F-I-L-L-M-O-R-E.
Say it again.
F-I-L-L-M-O-R-E.
It's actually only one L much.
Huh?
Fillmore is actually but only one L.
How long have you lived there, sir?
I just moved there for a couple of weeks
A couple of weeks? Where did you live before that?
on the street.
Okay. Well, who lives there other than you? Just you?
Yes, sir.
Well, okay, you're a transient. How are you? Are they giving that away for free, or do you have a job or something?
I received this as hospital.
Well, how long have you been in a transient though?
What you mean?
How long were you a transient?
He's asking how long you were homeless.
Oh, homeless. Years?
Not.
2 or 3 years?
Yes, sir.
Okay. Were you getting SSI then?
Yes, sir.
Where was all that money going?
I ain't have my car. My mother had.
Was that the question I asked you? Where did the money, your SSI go? This doesn't make any sense. So you were on the street, you don't know where it was going, but now all of a sudden it's going into your pocket?
I was incarcerated.
So help me out with that. Like I'm supposed to be clairvoyant? I don't know that. So you were in prison or something?
Yes,
Oh, okay. Okay. All right. For how long? What was that sentence for?
I was in almost a year.
Are you from what county? Jefferson County? What's the next page? All right, stop and go back. Please, slowly go back. There we go. How many? Looks like a bunch of controlled substance convictions, huh? Did you have an issue on controlled substances there? Or are you fixing that mess? Did you fix that mess? Controlled substances? Okay. Yes. Do you have a job now? Are you working somewhere? That's a good thing to have. You know, get you something to grab a hold of and keeps you stabilized. What do you do for a living normally when you're working? How old are you?
36.
Well, you got some kind of a trade or something, don't you? No? Okay. Well, we're going to set this for trial. What is, his bond on this place? What is your bond? Do you know how much? Is that 20,000? 15,000? Did, you had to post a $15,000 bond? Yes? Yes, because, okay. You did that yourself? Your mother did. Where does your mother live? Here in this county? Does she live close to where you live?
No.
Okay. She live in Beaumont? No? Do you see her regularly? Okay. You're laughing like, like
No,
that's
he has
not,
a nervous tick where he smiles when he gets nervous.
is that right? What's your next,
That's what I would.
what would be your next explanation if that didn't work? Oh, okay. All right, here's what we're gonna do is reset this for trial. And just have a seat before you leave, Mr. Lewis. We're gonna make sure that you're all drug-free based upon your history of drug convictions. We want to make sure that you're not ambling about intoxicated, okay? All right, get a resetting. Mr. Franklin.
Thank you, Judge.
What's up, people? Welcome everybody to the show. Oh boy, I got my merch finally. Time serve logo shirt. What's up, people? How we doing? We have a action-packed day of clips. We are gonna get rolling. I got Judge Boyd. I got Bryant, Thurston. Oh, there's a dandy out of Thurston. It's just hysterical. Right up this community's alley. Oh, how was that Stevens one? That Stevens was good. The scourge of the earth. You get rid of that drug thing? I love it. He's like the only judge on the planet that doesn't look at drugs as a disease. It's scourge. He's got like a 1958, 60-ish opinion of drugs before free love. Definitely. He is classic. All right, people, let's go. So let's get rolling with listen to what this girl is charged with in Millmore's court. Let's go.
You. And your appearance, please, Mr. Austin.
Yes, good afternoon, Your Honor. Jared Austin appearing on behalf of Ms. Hartwig for the limited purpose of this hearing only.
All right, thank you. Ms. Hartwig, this is file 23-01235FY. This is a complaint alleging on or about April 12th of 2023 at 4220 Pleasant Grove, City of Lansing, Ingham County, Michigan. Count 1 alleges that you did, in the course of committing a larceny of money, use force or violence against a person present, William Moore, and in the course of that conduct possessed a gun, a dangerous weapon. That is contrary to law. It is a felony, carries a maximum life or any term of years. Count 2 alleges that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit armed robbery.
Ooh.
And or assault with intent to rob while armed.
Did you hear that? Little hacker to commit armed robbery. Look at this little badass in a Barbie shirt. Killing it.
Contrary to law, that is also a felony.
Woo.
Maximum penalty, 20 years and or $20,000. You also would reimburse the government for expenses incurred in relation to violation in the manner indicated by MCL 769.1F. a consecutive sentence may be imposed for the underlying conviction. So do you understand these charges and maximum penalties, Ms. Hartwig?
Yes, I
Okay,
understand.
now, okay, you have rights. You have the right to plead guilty, not guilty, or stand mute. You have the
Use a
right to a
thug.
trial by a judge or a jury, and at that trial, you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one, one can be appointed for you at court expense. Additionally, you are presumed innocent, and if you're found guilty, it must be beyond a reasonable doubt. You also have the right to remain silent. Anything you say or write can be used against you, and you
Membership.
always have the right to have a lawyer present with you at any time
Thank
you
you,
are
Monica.
questioned. Do you understand those rights, Ms. Hartwig?
Yes,
All right. Is she applying for an attorney today, Mr. Austin?
She is, Your Honor.
All right, thank you. Ms. Hartwig, because this is a felony, you
What's up,
have
Easy?
2 hearings.
Welcome.
The first hearing is a probable cause conference that is scheduled for Thursday, June 22nd at 8:30 a.m. The second hearing is a preliminary exam scheduled for Thursday, June 29th, also at 8:30 a.m. Both hearings are with Judge Flores on the 6th floor of City Hall in courtroom number 3. Now, that first hearing may be held by Zoom if you're released on this. If you do not have access to Zoom, however, you would have to appear in person for
a
both
ginge.
hearings. Do you understand that?
yes,
Okay, and do you have the notice to appear and the Zoom
Yes.
instructions?
yes, I
All
do.
right, now, good, hang on to that. Now, Ms. Hartwig, is there anything I've told you that you do not understand?
No, I understand everything.
You're screwed. All right, next up, let's roll Judge Bryant. I dropped a video today of her being hysterical, kind, not being mad. But then, right after that, somebody pissed her off. And I got it. Let's roll. Welcome, all the new viewers. Welcome, welcome, welcome. See a lot of new people in the chat. Welcome. Here we go.
Your device together. Gentlemen, I am going to allow you to start your videos now.
Uh-oh.
Please start your video.
Thank you, monkey.
Well, this is probably why your stuff wasn't working and whatnot, because you trying to work and not in a place with a good signal. So, Mr. Evans, I need you to remain seated, stationary, in an upright position. Mr. Evans, don't interrupt me. I need you to remain seated, stationary, in an upright position, ready to attend court. I need you to remove whatever is on your head. And I need you to understand that the fact that you decided to go to work today is your issue. It is not mine. You have a court hearing this morning. And the fact that you did not take off work is your issue, not mine.
I didn't have any.
Sir, please stop interrupting me. I am not going to compete with your job this morning. I won't compete with your job this morning. I am going to send you to a breakout room. Please accept to join that breakout room. Wait in that breakout room for someone to come in to speak with you, but understand it was your choice to go to work today. You have a court hearing today.
May I say something?
Sending you, no, you may not. I am sending you to breakout room number 2, and whatever you need to say, you can say it to the lawyer that will come in there to speak with you. I am ready on Randall.
Bravo. Thank you for the dono. Monkey, you know I'll throw you in the sponsorship. Thank you, Daylight. Love it. All right, so Judge Boyd lost her patience today, and we caught it only here. Let's roll. Judge Boyd getting PO. Somebody just decided to leave. She had a court date. She left. Judge Boyd ain't having it.
All right, so we can have someone from the state.
Hank Wilkins for the state judge.
All right, court is calling 2023 CR 3770, State of Texas versus
thank
Donna Lynn
you.
Ellis. Can I have
Love
parties
it.
announced for the record
Loving
for the
this
state?
donos.
Hank Wilkins for the state, and we're ready.
Defense?
Monkey.
Count Roller here for Donna Ellis. We're not ready.
All right, this hearing was scheduled at 9 a.m. today. It's now 11:07 a.m. Your client did not answer docket call. Defense, do you have any idea where your client is?
I do not, Your Honor. I've had no contact.
All right, state.
Judge, we asked for bond forfeiture this time.
All right, because this is a PR bond, the court will issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, you're welcome.
Are we excused?
Yes, thank you.
I'm Gail.
Uh-oh, here we go. Yeah, I love Boyd Daylight. I could listen to her all day. Heineken with the $10 dono. Thank you, Heine. Thank you very much, ma'am. Much appreciated. The only problem is with her camera, if you get a tall lawyer or someone stands too close, hence what we're gonna see, you get like the cutoff. Like
All right, Caroline, listen, that's a
This-
judge's warrant and they're remanded.
here it comes.
All right, the parties on Migdalia Salazar. All right, counsel, it's the court's, we're going to go on the record. The court is calling 2021
Here
CR
we go.
9849, State of Texas versus Migdalia Salazar. Can I have parties announced for the record for the state?
Travis, thanks for the state of Texas.
Defense?
Charles Peters.
All right, Mr. Peters, where is your client? My understanding she was in court and she left.
I'm not sure, Judge. My office is attempting to contact her.
All right, my understanding is she was in court and she left the building.
I have no idea, Judge. I have just messaged for my client for the office to try to contact her.
All right, for the record, the court is going to note that your client was present and your client left. So the court is going to hear this order for judgment on nunc pro tunc. Have you had a chance to review the state's motion for the
I have.
judgment? Sorry?
I have.
All right, are parties ready to proceed? All right, court is going to grant the state's motion. All right, let your client know that their case is going to be reopened. Is there anything else from either side?
Nothing further from the state. Cool.
All right, and if your client needs to appear, counsel.
So when you say the case is going to be reopened, on what grounds?
Oh,
The state filed a motion to dismiss. According to their motion, they filed the motion in error. What they did was they filed a motion to dismiss based on the fact that the defendant was convicted or granted deferred adjudication in another case. My understanding is your client was not convicted or granted deferred adjudication in another case. And so that it was incorrect. And I have notated on the motion for dismiss after the court signed it, it says state and defense state reason for dismissal incorrect. Both requests dismissal withdrawn. So on that date, both you and the
No
state
problem,
asked that
Chris.
that dismissal be withdrawn and another dismissal be filed. And the court is not in receipt of another dismissal, and the court is not signing another dismissal until your client makes an appearance. Now, with regards to the nunc pro tunc, the court has signed it because the dismissal was entered in error. So the court assumes or presumes that the state is going to reopen the case. And for the record, the court is again noting that your client was here and your client left the court.
And on that matter, I do need to address an issue on the record.
Yes.
It's my understanding that the state has applied for a subpoena
Mhm.
in the companion case against Fidel Ayala. It's my understanding that there was an intention to serve Ms. Salazar today at court with that. It's
Well,
also
if
my
everybody
understanding-
would read the case law and realize that when someone is supposed to appear in
This was Boyd's camera. It's not the stream, guys. Because if you could hear it, so it slowed down. This is her cam. This was her camera.
court, I don't know if your client knew it or not, but once they appear in court, if they're here for a court hearing, technically they cannot be served a subpoena in court. But obviously, either your client was given bad information or your client decided to leave because somebody informed them that the state was attempting to serve them with a subpoena. When a person is ordered to appear in court, according to case law and the rules, they cannot be served at court when they have an order to appear in court.
I understand that. I
So,
also
who-
needed to address.
Who informed her
Ooh.
to leave the courtroom when the court ordered her to be here?
I didn't tell her to leave, Judge.
Oh.
So I don't know why she left. So, and we're attempting to contact her. One of the questions that I wanted to address is that the original dismissal was actually signed and entered. I received.
I can't believe you guys are going with iced coffee. I'm dead set on Diet Coke. She is a Diet Coke judge. I don't care what you say. Because she drinks that all day. That looks like a Diet Coke drink straight out of the Lone Star State. That ain't no iced coffee. That is diet soda. You guys are getting me a little upset. I thought you were going to go with a diet soda. Definitely.
The rejection notice of the case so that it is dismissed, which I believe ends the court's ability to order her to appear.
Here's the thing, what I need you to understand. What I want you to understand, if both the state and the defense on that date knew that that order was incorrect, that the state had filed the motion for dismissal incorrectly and said that she pled in another case, both the state and the defense told me, Judge, that's incorrect. She did not plea in another case. And then what ends up happening is another motion to dismiss is submitted to the court. And what I wanted to know from the both parties, because my mind is a steel trap.
I don't think she would be sipping water out of that kind of cup, though. That's like a diet soda type, and she drinks that every day. I think she had water. She would have like a hydro flask or just a straight up smart water. I don't think she's very classy. I'm not saying anything about that. I mean, she's got the roses, the tulips. I love everything about this judge, but that cup is Diet Coke. See, only on this channel do we get that far into what she's drinking. Yeah, it's because I don't know the law, so might as well talk about cups. Oh, we're such nerds. I love it.
I wanted to know why the case was being dismissed. The state said it's because we cannot get in touch with the complainant. And I asked the state, who is the complainant? They informed me it was a child. I said, how can you not get in contact with a child? And
guys, if you say the chat messing up, I watch a couple sport channels and it does the same thing to me. It doesn't do it on my computer or my iPad or laptop. It only does it on the phone. So it's definitely something going on with the phone. I don't know. I'm going to Google it because it happened to me on my sport talk that I was listening to right as I was getting ready for this live. It does the same thing. It like stutters. It does that on a couple channels.
I said that I wanted the caseworker here because both the state and the defense informed the court that the CPS caseworker had closed the case. And I said, well, I would like to hear that from the CPS caseworker. And both parties like, no, that's what the CPS caseworker said. And I said to both parties, do you want your bar card on the line for that? And then both of you all backed off and said, we will get the CPS worker here either by Zoom or in person.
I would actually like to correct that, Judge. I believe at the time that I stated that I was willing to proceed without CPS caseworker.
No,
present.
you both said that you would not put your bar card on the line just by saying that, and that the CPS caseworker would
I
be
do
here.
also would like to address that I believe that there was a second dismissal that was submitted with that different.
Which I did not sign.
Is it still part of the court's file?
No, because I did not sign it.
So it was discarded?
I did not sign a dismissal. And what everybody needs to understand is that the court can sign a dismissal or not sign one. I chose not to sign it. And if that dismissal were placed in the court's file, it would not be valid because the invalid dismissal that I just did a knock on would be the law of the land. So thank you. Court is
I have
calling.
one final issue to
Yes.
address on the record. It's my understanding that
Love her.
there was an ex parte communication between Brittany Mitchell on behalf of the state of Texas
To who?
and the court.
No.
Your Honor, he's just referring to discussing the scheduling of this hearing yesterday when y'all discussed that we have this hearing.
No, I told the court coordinator to put this on the docket for today. And this case was supposed to be on the docket before then, because when you both were here, I gave you a date for you all to appear. So the court does not do ex parte communications. Thank you. Court is calling 2023 CR 327.
She's so thorough. You know she is. She knows everything that's going on everywhere in that courtroom, in front of her, in her office, all the time. So he better come correct if he's trying to match wits with her. She was like, nope, 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 nope. Please. Next. Love her. Love a good Judge Boyd. Oh. And the fact that she keeps her streams up is just fantastic. Okay, I have two really good Judge Braunlick. This guy, I think I'm going to save this one. We'll do Mr. Brown first. So we're going to go to Mr. Brown, and then we'll do a little DeSanto after that, a little Bryant, then we'll go to the main event. Here we go.
Current address, Mr. Johnson, make sure you update the file.
It's 4019 Overland Parkway in Toledo, Ohio.
Okay, that's the address we have on file for you. Ms. Six, what's the situation with Mr. Johnson that caused him to appear this morning?
Your Honor, Mr. Johnson's case was adjourned over to today's hearing following an appearance in May. Initially, he had a bench warrant. He was arrested on his bench warrant and posted bond in March of this year of that $500 cash bond. We forfeited the bond and adjourned it over to May. At that May hearing, he agreed that he would pay $232 by May 19th and an additional $230 by May 31st, and we put it over to today's date to monitor. He made a $100 payment. This case charges at $232 per month. His arrears are $6,603.41. This morning, he met with Ms. Brower from the front of the court. He told her that he's making $100 to $150 a week, but then he also told her that he has a $900 a month rent that he pays, so that doesn't really even add up for that. He's not been making his payments. He's not been consistent. His jobs that he's doing has been Instacart or DoorDash versus a more permanent job. And so at this time, the front of the court is asking that we move forward with contempt.
All right, Mr. Johnson, can you make a payment today?
At best.
Yes, I can actually.
Okay, because otherwise, if we move toward contempt, you're walking yourself closer to the jail.
No, I understand this, and I'm actually hoping that there was something else I could do. See, I mentioned earlier, also signed I had a motion filed, which I was actually not really able to afford, but did. And I've been trying to say that I don't make the same amount of money that I have been making for the
I'm Rick James, bitch. I saw that. Good one, Lisa.
past couple of years. And the same job that I had when I was supposed to pay $260 whatever a month, like I'm not able to do that anymore. Like I've been trying to make this clear. I've been asking if there's anything I can do. I'm not able to pay maybe what you guys want at the time, but I plan on paying the full amount. This has happened to me before and I wasn't able to even go in front of a judge. I didn't have to. I ended up just paying it myself through working, and then they take it out of my check. And like, I know I haven't been as responsible as I should be, but I feel like going to jail for 45 days would just mess up all the progress that I have been making, and I won't be able. I'll be in a worse position then getting out than I am right now.
Okay, Mr. Johnson, obviously you have to get a legitimate full-time job. But unless you're disabled, you need to have a full-time job. In front of the court is a 4-page list of employers in Northwest Ohio and Southeast Michigan that are screaming for employees. I can get you a job today, 40 hours a week.
How come every time Judge Braun offers a job, not one deadbeat father or mother for that case ever says, "Yeah, can I have that list?" They act like he never even said it. And Judge Anzalone says it. I'm trying to think other judges. All of them say that. All of them, Mike Page, all of them. Not one person says, "Can I have that list? Can you email that to me? Can you text that to me? Can you have friend of the court send me a list?" No, they just like this. Okay. I don't want to go to jail, but I don't want to work, but I don't have money to pay. Do something for me. Help me. Can't.
Mr. Johnson, so there's a lot of jobs out there. Now, you previously agreed you could pay $232 by May 23rd, another $230 by May 31st. You've not paid that. So if you you need to make a payment today if you want to. Otherwise, we're going to start with the contempt proceedings, and I'll appoint an attorney to represent you. So do we want to go there, Mr. Johnson, or can you come up to Monroe and make a payment today of $500?
So it would be, I would have to pay no less than 500.
Well, you got arrears of 6,000, yes, and you've not. Then again, you got to file a motion to reduce support. If you're claiming I'm disabled, I can only work DoorDash 20 hours a week. You need to file a motion to reduce your support. Right now, it's $232 a month.
And you know what? You know what else pisses me off? There's nothing wrong with DoorDashing. I don't know about in his area of Michigan, but in Jersey, around by me, I did it one year during the summer. I said, this summer I'm going to take off, not do anything, just enjoy it. By mid-July, I was ready to kill myself because I was so bored. So I said, you know what? Let me try this Uber thing. This was years ago. I did the Uber and I did Uber Eats when it just started. I busted my ass. 20 hours a week is nothing. He's doing nothing. He can make a decent living for himself and pay that measly child support on a DoorDash salary. I'm sorry, you can. 20 hours a week is nothing. That's him working, 4 hours a day? If that, 4 times 5, 4 hours a day, not working on weekends. Come on, man. He doesn't care. DoorDash. I'm not making it enough with my DoorDash to pay my rent because you're not working, bruh.
I'm aware.
If you want this matter put over for another 45 days, you need to come up with $500 today in cash and bring that up here.
Heineken, it could be a good job if you apply yourself. He's not looking to make $100K, but just to not go to jail for Christ's sakes, come on, it's perfect. He doesn't care. So a lot of people don't even have the car or the means to do the DoorDash. So he's just slacking. Let's just get to the bottom.
If you can't, then I'll appoint a attorney to represent you. We'll set for a hearing later this week.
Okay, is there any way?
Welcome, T.
Okay, what about my motion? I'm supposed to have court in a few weeks for that.
Okay, I don't know when the hearing
He
date is.
does have a motion scheduled before referring the
filed
key,
it
Your Honor.
the same week, like right after my last court date.
Okay, but if your support is reduced, maybe to $150 a month, you still have arrears of $600, $6,000, and not many payments at some time.
No, I understand about the arrears. I'm saying I plan on paying it all. Like I will pay it. I'm not trying to get out of paying anything. I'm not even trying to get
But
anything.
Mr. Johnson, the talk is cheap. We need regular, consistent payments. We just can't say what.
Judge Brolick said, talk is cheap. Show me the money.
I'm gonna pay. We need regular, consistent payments. Not say, well, yeah, eventually, sometime in my lifetime, I will pay. And we need regular, monthly, or regular, consistent payments. So can you pay $500 today?
No. Look at him.
What about?
All right, there be no response.
No,
Mr.
I don't
Johnson,
know.
let me inform you that if in fact the court finds you to be contempt of court, you could be ordered to serve up to 45 days in jail. Because of the possibility of contempt, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. You want a court-appointed attorney, Mr. Johnson?
If I'm in contempt of court, would that
You want a
mean
court-appointed
I'm
attorney,
charged with
Mr.
a
Johnson?
would I be charged with a felony?
No, it's not a felony. It's up to, I said it's punishable by up to 45 days in jail.
Oh, then you know what? Lock me up. I'll take a little vacation. 3 squares. Don't have to DoorDash. I'm at 123 Kirkland Drive over here. Come get me, Judge. And I don't have to pay the $500 today. Let's go.
You want a court-appointed attorney, Mr. Johnson?
Look at him.
Not at this time.
What? Why?
Well, we're going to move toward jail, so I'm going to appoint an attorney to represent you, Mr. Johnson. Why don't you give me a phone number? I can have that attorney reach you.
734-770-7069.
Hang on. 734-770.
7069. And if I'm able to bring $500 up today, then what would that do?
Well, I don't know. I mean, I asked that and you wouldn't give me an answer. So we're going to set this for a hearing.
Well, the thing is,
I'm
I
gonna
don't
order that you
have
personally
$500
appear.
right now, but I could try to come up with it before 5 o'clock.
Well, you may be able to. So I'm going to set this for a contempt hearing on Thursday of this week. That's June 15th. You are to personally appear in the Judge Brown's court, fourth floor of the courthouse, June 15th. Ms. Six, what amount would be appropriate for Mr. Johnson to pay that would avoid any immediate jail?
$750, Your Honor, would be, then he would have made his April, May, and June payments.
All right.
Oh.
All right. So, Mr. Johnson, you're to personally appear June 15th, 11:15 a.m. in the courthouse, and the attorney will contact you by phone. We'll talk with you between now and Thursday. So it's Thursday of this week, June 15th, 11:15. Personally appear.
Oh, donos from Mark. It's 420 somewhere. Puff, puff, give out memberships. Judge Mark does not
And
like.
if in fact Ms. Six is suggesting that if you pay $750 before you appear in court on Thursday, then you can avoid any immediate jail. You may be held in contempt, but it'll be hanging over your head. You won't serve any immediate jail. That's what Ms. Six is suggesting. Sounds reasonable. Do you own any, let me ask you a question. Do you own any property of any value, Mr. Johnson? Do you own like real estate, boats?
No, the only thing I own is my vehicle.
My vape.
Which is not this one that I'm selling.
Okay. Well, what year, what model of vehicle do you own?
It's a 2006 Impala L2.
Ooh.
Do you have any bank accounts?
No.
Yes.
Chime.
A Chime account.
Okay. How much is in your Chime account?
As of right now,
$7.
Like maybe $5.
All right. All right. Right, court grants request for court appointed attorney. Again, you order to.
Okay. I don't get it. There's been times when I first became a widower where I had to adjust. I never lost my job, always had a good paying job, always had an extra job. There were times during COVID, I was stretched. If I had less than a certain amount of money in my bank account, I couldn't even close my eyes, let alone sleep. How a grown man walks around with $5 in his pocket and doesn't care about that amazes me. I don't care white, black, brown, red, yellow. Just a man, woman. I don't get it. Even not being a father, like, you need something. So when I was a little stressed out a couple years ago, I was like, I gotta go get another job. And I was fine. So, and I don't want to hear the snowflakes. Oh, well, he's struggling and blah, blah. Dude, turn your car on, go DoorDash. You'll have $100 in your account by the end of the day. Like, but there's just no motivation anymore. I'm sorry, I'm preaching today. It just really gets to me. It really pisses me off.
Here personally, 4th floor of the Monroe County Courthouse, Thursday, June 15th, 2023, 11:15 a.m.
Correct, Crystal. Correct.
Court would strongly encourage you to reach out to family and friends, come up at 7:50, bring it up in cash that morning. You can you'll be able to get home for dinner. Otherwise, they can they'll serve you jail lunch at the court in the jail.
Heineken. Yeah, he starts to lose sleep around $2. That's his limit. When the chime doesn't chime, it's more of a siren. You broke.
Do you have any questions, Mr. Johnson?
What about my motion?
Correct.
Ms. Six says it's set for hearing, which is good that you're at least moving forward in terms of reducing your support. What was the date? You did indicate that record and Mr. Johnson spoke over you, Ms. Six.
It is currently scheduled for June 27th with the referee.
Okay, so that's a.
But Shaquille, I'm not laughing at it. I understand, Shaquille, but I've known you for a while in these chats. I may not know you personally, but I'm sure you were doing everything in your power to not be broke. That's what I'm saying. There's nothing wrong with being broke. There's nothing wrong with that. It happens. It's life. Life sucks. What I'm saying is not giving a shit that you are and that everyone owes you because of it. That's the difference, Shaq. That's what I'm talking about. I'm sure there's a difference between hitting hard times, being broke, but doing everything in your power to try to not be broke. Not throw yourself at the mercy of the court when you're in a working car to go DoorDash.
It's scheduled for June 27th. You'll get notice of that. And of course, you can get a copy of notice. You have now received mail when you come up on Thursday. But hopefully that will reduce your curse word. That's good that you're taking some steps rather than sitting on your hands, Mr. Johnson. I give you credit for that. But that is not going to reduce or affect these arrearages. It'll just simply help in the long run. All right. If we have no other questions, Mr. Johnson, we'll see you on Thursday at 11:15.
All right. I have no other further questions.
All right. You can zoom out. Thank you, Ms. Six.
Thank you.
Here's the question. The next time we see Mr. Johnson, will he be in stripes or won't be in stripes? Guarantee you this guy's in stripes because he's got that attitude and he don't care. He already owes $6,700. Come on. All right, let's go to Blue Hair, Don't Care, and Judge DeSanto. Actually, she cares a lot. She's crying and oh my God, poor Judge DeSanto. I don't know what's going on in her courtroom, but she is getting. It is. Whoa. Every day gets worse.
Sir.
You remember him? Mr. Bud Light shirt? Mr. Bud Light. He ran out on his urine screen. There was an update on him. I dropped a video on that one if you want to see that.
the court's
All right.
going to
Let's go to blue
hope
hair.
that, your mail came back from your address there on 8th Street. However,
Actually, you know what? We'll go to this dude. This dude's great. This guy.
find out for William Lynch III, 221708.
Oh, sorry, guys. Hold on.
Appearance, counsel?
Your Honor, good morning, Richard T. Serrano, P33828, I appreciate that I was counsel for legal purposes only. On behalf of Mr. William Lynch, who is presently in custody. Please state your name, sir.
I apologize if my logo is in the way. When I'm at work and I'm recording, I forget that the logo's there and it starts self-recording and I forget. All right? So let's just watch. I'm sorry.
William Lynch.
All right, thank you. And counsel asked for the arraignment.
Your Honor, I've had an opportunity to speak to my client regarding the nature of the charges. He understands them. He also understands all the constitutional rights to continue throughout this case. Thereby, we wait for him reading, stand mute.
All right, the court's going to read this from a reading, enter plea of not guilty for purposes of the arraignment. And counsel, as this is a wind-up matter, did you pre-try the matter or no?
Your Honor, I asked about that, and the prosecutor said, as well as the court officers, that we are to arraign only today.
Oh, that's fine. I just wanted to confirm
Yes,
that that's what occurred.
so we have to pre-trial.
All right, the court's going to enter indicated pre-trial in this matter will be on June 27th, 9 a.m. And counsel asked to bond.
Your Honor, first as a matter of housekeeping, my client has a new address he wants to place in the court file.
Let's see here. Yeah, so I see the address he threw on his paperwork, correct?
I believe so, he put the most current address. And as to the,
I just one question. Sir, is that 7-3 or 2-3? 3023 or 3073?
3023.
Okay.
Monica throwing out.
All right, I'm sorry, counsel, go ahead.
No, my client feels that, he is currently on probation in Monroe, on a felony larceny. And he informed me that he's pretty sure that Monroe County is coming to pick him up. So I think the point of bond at this point is, his point. If he were released, he would go back to that address, Your Honor. Other than that, he has some matters pending. He probably should appear back in court. There are no crimes of violence that I see, Your Honor, that he has pending, or in his past. So consider that.
Okay, and the court is pretty certain that Monroe will be coming to pick him up, and if he doesn't, the court's going to address bond. Because Mr. Lynch was supposed to have been here in this court in September, and he failed to appear, and so the court issued a warrant for his arrest. And so how did you end up in custody today, sir?
What's that?
What?
How did you end up in custody today?
I don't know.
I was walking around. I have had back problems and I was walking down North Line and people were calling saying that I was walking drunk, but I wasn't drunk.
Okay, so you live in Monroe, and yet you were somehow in Wyandotte yesterday, and you were able to get yourself arrested and in custody.
Yes, I just left the hospital yesterday.
I can't.
You were in Wyandotte Hospital?
Yeah.
So how did you end up in Wyandotte Hospital instead of a hospital down there in Monroe?
Cause I was out here, my kids live out here.
Okay.
Sure.
And sir, if you were to test today, what would be detected in your system?
Everything.
Oh, heroin.
Ooh.
When's the last time you used heroin?
Yesterday. I'm starting to get so sick now.
At least he's honest.
I'm starting to be sick now. Withdrawal.
Oh, from withdrawals? Okay. So, and what matters do you have pending, sir?
Oh, I got probation violation in Monroe. They're coming to get me. I'm definitely going for a while.
Okay, and what is your probation violation out of Monroe?
For using drugs.
Tough.
So okay, so you're on probation for felony larceny, and what you tested dirty for your drug test. And so then there's a probation violation, and you didn't appear for it. Right, okay. So the court, you have not much confidence that you would appear in this court if this court were to grant you a personal bond. We've been waiting for you since September, and you haven't appeared, you haven't contacted the court. And
I didn't even
therefore,
know I had a court date here. I didn't even know I had a warrant here at all.
sir, the court will note that your mail came back from your address there on 8th Street. However, you were issued a ticket for the possession of drug paraphernalia and public intoxication back in August of 2022.
I don't even remember having the ticket.
Okay, well, it was given to you. You weren't arrested. It was given to you. And so that is your responsibility, sir, to follow up with that.
Okay.
So I think part of the problem when the state made the changes that it did, as far as when to arrest and when not, is it gave a little bit too much credit to individuals that can't seem to remember when they received a citation or not. So that's on you, sir. The court's going to indicate a $7,500 10% bond. In the event bond is posted, you're not to be released without GPS tether through the Wayne County Jail. House arrest. Not to possess or consume any alcohol or drugs unless prescribed. Thank you. Have a good day.
Tough.
I'm going to be off the record.
All right. I got 3 fantastic clips coming up. All right, we're gonna do DeSanto, and then we're gonna go Bromlick, and then the Dono clip of the night. The Dono clip of the night is special. Oh boy. Here we go. You know, we had someone who worked for CSI Las Vegas. Do you know that? In DeSanto's court today? He worked for CSI. Swear. Swear.
Okay. All right, please have a seat over probation. Somebody will be with you shortly.
Thank you, Judge.
Thank you. Have a good day. Okay. And then this is the one in Covey.
No, there's 2 of them. He just walked out with the file that we're supposed to do first.
Sir Gerald was in custody again?
And that bailiff looked like he's sleeping all the time. I got to get him back into the screen. Hold on. Oh, boy. All right, here we go. DeSanto. How are you, darling?
Okay. Well, and they're both gone. Okay. Well, we're going to be off the record for a moment. All right. Let's handle.
They're, in the meantime, they're back there.
I know. All right, we're going to go on the record. Oh, there's Mr. Gopal. Okay, you ready, Mr. Gopal?
Yes, sir.
Thank you, Mark. New hat fun. Love it. Thank you, sir.
Right. Oh, Mr. Howe's back too. Oh, you got both of the returners? Mr. Howe, Mr. Gerald. Okay.
Mr. Howe.
Mr. Howe, isn't that your first one in custody?
Yes, that,
No, he's been here before.
oh,
Hasn't he?
I believe so, Your Honor.
Yeah. Pretty sure. All right, we're on the record in the matter of the city of Wyandotte versus Richard Howe, 231404. And appearance, counsel?
This is a twofer. Enjoy.
Today was a time set for a arraignment and pretrial. I have met with Mr. Howe at this point in time. Mr. Howe, would you please put your name on the record? Come on, let me just unmute, but counsel, just for clarification, he's in custody, so it was actually just an arraignment, but you ended up pre-trying it. I see. Your Honor, I agree. However, when I looked on today's docket, it is scheduled for arraignment and pretrial. I understand it was in custody at the time as well. That's why I was. Oh, I don't have that on my docket. Oh, because it was in, okay. All right, okay, that's fine. That's fine. And I did, but we're going to just, at this point in time, okay, let me have Mr. Howe put his name on the record, please. Mr. Howe, your name for the record, please.
Richard Lee Howe, Your Honor.
Okay, and so counsel adds to the arraignment.
Your Honor, at this point in time, he's charged with public intoxication, stand new to those charges, waive a formal reading of those charges, ask for a plea of not guilty.
Court will waive the formal reading after plea of not guilty for purpose of the arraignment and ask the pretrial counsel. Your Honor, at this point in time, I have had some discussions with the city attorney regarding this matter. We are asking for a second pretrial of the opportunity to receive the discovery in this particular matter. I believe the discovery order has been signed. Yes, I had signed the discovery order. So counsel, your option would be either June 28th or, I'm sorry, June 27th or July 18th.
Pick a day,
I believe that July 18th, that will give us opportunity to get the
David Cam. Oh.
July
What
18th
up,
at
Dave?
9:30. And yes, to bond counsel. Your Honor, at this point in time, we would ask for a personal bond in this particular matter. I reviewed the discovery. It appears that he is charged with public intoxication. He was basically, when he was speaking to the arresting officers, he was in that bar after they had spoken to some other individuals regarding the original call. And while in that bar, they spoke to him, asked him to come outside, and then he was charged. This is not a situation where an individual was wandering down the street in a drunken stupor. He is intoxicated, but my understanding is he was 0.24, I think, where he voluntarily took a PBT. For those reasons, Your Honor, personal bond. He is on Social Security. He was for a period of time, I won't use the word homeless, but was bouncing between locations. My understanding is that the address on the register of actions is not accurate, and that he is now residing with friends. Is that correct?
Denise.
Pardon?
I think he said his niece.
Denise, yeah.
So we're asking for a personal bond in that particular matter, so he can address these issues. He's also on probation, and they all should be aware of this. This is not a third trigger. Mr. Howe?
Yes, Your Honor.
This is not your first rodeo, is it?
No, Your Honor, it's not, no. Got a bad alcohol problem.
Yes, you sure do. We've already discussed that on previous occasions.
Yes, Your Honor.
Stay out of the bars.
Yes, Your Honor. Go back to AA meetings, what I gotta do.
Who's worse, Stevens or DeSanto? For least compassionate judge for drug and alcohol problems, probably DeSanto.
Sir, you may have to go inpatient is what you may need to do. And you're on probation, sir?
Yes, Your Honor.
And is one of your conditions of probation that you're not to consume alcohol?
No, I'm not supposed to know.
He's an alcoholic.
Yet, you're in a bar and you have a .24.
Yes, Your Honor. Yes.
The court's going to indicate, based on the fact that Mr. Howe is on probation and still violating court orders, the court's going to indicate a $2,500, 10% bond. He is not to be released on alcohol tethered through the Wayne County Jail.
Yeah, throw up those DeSanto emojis.
So, sir, what that means is that if you consume any alcohol while you're out on bond with the tether, they will come and arrest you.
I know that.
I'm sorry?
I said, I know that, Your Honor. I know that. Yes.
Hopefully that's the motivation for you to not consume any alcohol.
Your Honor, you said 25,000, 10%.
2,500.
45,000. And that attorney, he needs to go. He makes so many mistakes on a daily basis. It's sickening. She just corrects him all day. That was like the 4th correction. If you listen to DeSanto all day, hardcore, that's exact. 45,000. The other day it was like 100,000. She was like, "It's 1,000." He's like, "Oh, sorry." Big mistake. Okay, now we have if Smeagol and Popeye had a child. This is our next defendant.
All right, thank you. We'll see you back on July 18th, and we are still on the record in the matter of the why not for another familiar face, Gregory Gerald, 231418.
Where the hell did he get that shirt? CSI Las Vegas and Wyandotte. I can't.
Hello, ma'am. Sorry.
Sorry.
And Mr. Gopal, is this one of yours as well?
Yes, it was Your
Oh. Pluto stole my goal. Billy. My goal. It's Pluto, Billy.
All right, your name, sir?
Pluto.
Your name?
I love you guys.
Gregory Gerald.
Okay. And counsel adds to the arraignment.
Your Honor, you stand mute to the charge. This charge of public intoxication as well as open alcohol in container. Your Honor, he would plead waive of formal reading of those charges, ask for plea not guilty, be entered on his behalf.
The court will waive the formal reading and plea of not guilty for purposes of the arraignment. And as to the pretrial counsel.
Your Honor, I discussed this matter with the city attorney. It's my understanding that in return for the plea of guilty to the open alcohol, the public intoxication charge would be dismissed. I explained to Mr. Jarrell as best I can that he would be waiving certain constitutional rights by entering into this plea. I also explained to him that by entering into this plea, if he is on probation or parole, this would have an adverse effect on that as well. Understanding all of that, it is my understanding he wishes to avail himself of this opportunity. Is that correct, Mr. Jarrell?
Oh boy.
Well, no, I'm not on probation, parole, nothing like that. Your Honor, like, can you hear yourself, sir? I apologize. If I could be like if I was able to be placed on probation for this and actually, to where I have to report and actually like pay off like the fine on it or something, like I wouldn't mind actually. I had to, you know, my birthday was yesterday, man, and I never want to drink like again, like literally, like I'm to that point, like I'm being dead honest. telling you the truth, like what I've been through. I just now got out of jail recently. The last time I apologize to the fullest extent, like, you know, I feel like a dumbass, like, I don't know, like, when I was.
Mr. Terrell, Mr. Terrell.
Hey, Mr. Gerald, okay, I may have a friendly face, but we're not just having a casual conversation here. You're in court.
Yes, ma'am. I
So
apologize.
please,
So he's been in her court many times. She's saying, "Why are you like casually talking to me?" She addresses this a couple times.
think before you speak with the language that you're using. Where did you just, when were you just released from jail?
I wanna say 3 weeks ago. But I was actually in a mental health facility too as well, was like medical with two weeks of that in there, about 15 days. I forget the name of the treatment facility that it was.
Okay. Here's the thing. So Mr. Gerald has an issue with alcohol.
I know it is.
Clearly.
I've dealt with him before.
So, and I understand you worked hard for this plea, but I'm going to adjourn this matter and I'm not, because I want to see, I need to pull out some of the other cases that he's been before the court on to see what that is, because I thought that he was, which court were you just sentenced to jail in, sir?
Which court was I just, it was here. It was out of Wyandotte.
Yeah, so it was this one. I just sent you to jail.
That's correct, sir. I handled that.
I did 76 days and
Right.
26 days jail credit and a little bit more. And I'm being honest, like I promise I'll never sit here and drink like this in public no more, nothing like that. I'm gonna go to chapel or something. Try to get a little bit more help.
I'm pretty sure I heard this from you when I sentenced you last time too. And
No,
yet, here we
not
are.
this time. But I apologize, you know, like I feel like literally like a dumbass, man. Like I'm praying to God or something.
Look at her.
Have this friendly face to just have a casual conversation with.
Look at her. She's stunned. Ready? Watch.
Like I'm praying to God or something.
Have this friendly face to just have a casual conversation with. We're going to adjourn the free trial. We'll do June 27th.
Oh, we'll be there. Adjourn.
10:45 a.m.
Look at him.
And that's the bond counsel.
Your Honor, you heard Mr. Giroux. He has, clearly has a mental problem. There's no doubt about that.
Yeah, he
He
does.
also has, basically, he is residing in a homeless, so he is going back and forth between France. He works part-time, odd jobs.
So he doesn't work.
Sometimes, like what I've been doing.
Hold on, sir. Please don't interrupt. Your attorney's speaking right now.
And I would suggest, Your Honor, based on the discussions, the court is well aware of Mr. Giroux. Yes, you know, it's sounds silly.
As the world turns, so does DeSanto's chair squeaks.
He's asked me to ask. He would like a personal bond, Your Honor. However, clearly, if
Look at her face as the chair moves. I swear to God, it looks like she's farting. It looks like he's passing gas while he's talking. Watch. Ready?
He's asked me to ask.
Look at her
He would
face.
like a personal bond, Your Honor. However, Clearly, if.
Please stop interrupting. I see your hand raised, sir. It'll be just a moment.
Yes, ma'am.
Clearly, Your Honor, any kind of bond would also entail an alcohol tether. The court has adjourned the pretrial, understanding what the plea hopefully will be to one half dozen of the other as part of the plea agreement. And so, with that said, Your Honor, I would ask for a personal bond with an alcohol tether. He can't make any type of cash bond. And I do understand the court's concerns. If the court
I am.
then tether him
I am. It's terrible.
to a inpatient facility, such as.
I would love to do that, counsel, but Wayne County Jail has said that we can't do that anymore. They don't have that. They don't have, I don't know if they don't have those contracts anymore with the facilities, I don't know.
Okay, and I did receive one on another person regarding mental health court, not in this court. But it should go, the rules you had to jump through, so it's gonna be interesting on that case. With that said, Your Honor, I think that cash bond is two things, or even 10% bonds. Is he a danger to the community? No. Is he a danger to himself? Yes.
Yeah.
There's no doubt about that.
Think so?
He has to control and overcome his drinking problem. He's admitted to me
because of the drink
over and over that he does have his drinking problem. However,
Lisa, I can't.
The alcohol tether, even a personal bond, would would then at least deal with his drinking to some extent. And as you've said to so many other people, if you drink an alcohol tether, they're gonna pick you up and put you back in jail. And for those reasons, I would ask for a personal bond with alcohol tether.
Okay. Well, and counsel, I understand that you said that you don't think he's a danger to society, but he has some charges on here that there was a misdemeanor sex offense excluding assault and commercializing, that was amended to a disorderly. Then there was misdemeanor invasion of privacy.
Invasion of privacy.
Amended, and there was additional charges of retail fraud, disorderly, trespass, felony larceny, felony receiving, concealing, and so for those reasons, the court does find he's also a danger to society. What is you raised your hand, Mr. Gerald? What would you like the court to know?
Like, I apologize for everything that I've got myself into. If you can hear me out, like, I promise, I promise you got my word. All right, you got my word. This is my promise. Like, I'll quit drinking. If you can help me, like, I'm not lying, like, to where I can be released, where I actually ain't going through, like, the jail and certain things. I'll check myself into a hospital or something, ma'am, if I have to. I don't, like, I don't know what to do. Like, I'm telling you the God's honest truth. Like, I will, if you can understand me. But I'm not trying to.
So here's what I'm going to do. Because the court does find that based on your criminal history, the charges, the fact that you do pose a danger to society as well as yourself, the court's going to indicate a $2,500 10% bond. The event you post bond, you're to have an alcohol tether to the Wayne County Jail. If you need medical attention, sir, there are medical facilities there within the Wayne County Jail.
No compassion. None.
Ma'am, like,
heartless.
I got a couple cigarettes.
Alcohol or drugs unless prescribed.
I got a couple cigarettes in my backpack, but I don't know if I'm able to smoke a cigarette or nothing like that. But I would greatly appreciate it if I could actually smoke a cigarette. Like, I'm sorry asking. I'm so stressed out, man.
No, no, sir. We are not going to have the officers go into your belongings and give you a smoke break. That's not how that works. All right, thank you.
Definitely feel bad for
All right.
him. But he's got a long rap sheet. He's strong to the finish till he gets a quiddish. He's popped by the sailor man. Okay, here we go. Braunlick, main event time. We have douchebaggery at its finest. Right now, main event, then the dono clip of the night. Here we go. Nope, that's not it.
All right, please.
All right, here we go. Oh boy. So, here's our dad, okay, Joshua. We lose him video-wise. So, if you don't see him, his video's screwy, whatever he says. But I think just hearing him is even better. So, let's roll. Trashy mom, check. Jerk off dad, check. Michigan custody battle, check. Main event. Here we go. She has scripture on her cleavage. So instead of the Nazi insignias, last mom, we have scripture. At least we get to see what dad.
My video's glitching a little bit, so I'm on here, but it just keeps flickering. So
Okay,
I'll-
then just,
I'll-
you can turn it off, just as long as we can hear you.
What the hell
Okay.
kind of computer does he have? He's an alien. I'm sorry. No device I ever had glitched like that. I'm sorry. And I don't have like top of the line stuff. Oh, mom looking good for judge.
It's now
Oh.
session, tap page 1, Joshua.
If you have seen Miss Nemec before, she's been in Braunlick's courtroom before, and I think Pac-Man. She's good. You don't want to mess with her. She's good for us, bad for everybody else.
Boucher versus Amanda Sharp.
Oh
The record
boy.
of this matter is before the court for the purpose of reviewing plaintiff father's parenting time as well as a front of the court parenting time show cause complaint directed to the defendant mother. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the defendant mother, Amanda Sharp. Ms. Sharp is present. Is Joshua Peugeot present on audio?
yeah, I'm here, I'm here, Judge, Your Honor.
Good morning, Mr. Peugeot. The parties have
Correct,
conferred
Heineken. Trash can dressers.
this morning with Mr. Walker for the front of the court. Mr. Walker has provided the court with the following recommendation. That a family counseling and shelter services family contract shall be incorporated into this order. Is there a written report, Ms. Nemec, that will be attached to this or somehow included in the court file? Because this court has no idea what the provisions of that family contract.
It was
Right, for it.
incorporated into the prior order, Your Honor. I can provide the court another copy of it, but it was the agreement that Mr. Puget and the minor children arrived at with the assistance of Ms. Team at Family Counseling and Shelter Services when they were engaging in therapeutic parenting time there.
Okay, so that therapeutic parenting time would continue? Is that what you're suggesting?
No, they previously engaged in therapeutic parenting time.
Correct.
As part of the therapeutic parenting time, they created a family contract to carry them into the next stage, which was the unsupervised parenting time, which Mr. Puget has been exercising.
Okay.
And
So does that contract provide for specific conditions or terms for that unsupervised parenting time?
yes,
Okay.
certain
Do those need to
things,
be spelled out into this order? I mean, if there's an issue in the future, how's the court going to know what the order provides for? That contract, I should say.
I understand, Your Honor. I believe that we provided it previously, but I can read,
Okay.
it's 4 pages long, but I
Okay,
can
maybe
read.
the friendly, Mr. Walker, does friendly court have a copy of that? There's nothing in the court file, I'm just saying. So Mr. Walker, as long as the front of the court has a copy of that contract, then at least the front of the court can assist the court if there's an issue in the future.
Your Honor, I'm not sure. I'd have to look through our file, but if Ms. Nemec could email it to me, I can make sure that it gets in the front of the court file.
I will email it to you as soon
Okay.
as we are done this morning.
All right, that will work then. Okay. It's further, so it's recommended that that contract be incorporated into this order. The party shall continue to comply with the terms of that contract, the terms of which are unknown to this court. But further, that father shall have parenting time every Saturday from 10 a.m. to 7 p.m. and every Sunday from noon to 4 p.m. It's further recommended that father's parenting time complaint be denied. That the party shall provide proof of any ongoing CPS investigation or police investigation or criminal charges against father prior to the next hearing. Neither party shall leave any drug or marijuana paraphernalia in the presence of the children. All prior orders not inconsistent with this order shall continue. The parties will appear before this court to review parenting time in about a month, maybe July 19th, 2023 at 2 p.m.
I'd
So
like to say something, Your Honor.
Yeah, first
the
of all,
No,
hold
sorry.
on just a minute. Ms. Nemec, is this recommendation agreed with your client?
It is, Your Honor.
All right, Mr. Peugeot, do you understand, first of all, the recommendation?
I understand the recommendation.
Okay, are you opposed to the recommendation?
The thing about the recommendation is both the cases are closed. I've turned in the CPS case closed to the friend of the court. They already have a letter from CPS saying that case is no longer being investigated and it's closed. I turned it into the court and the friend of the court, actually. I turned it into your office too. But the investigation from the Dearborn Heights Police, that's closed also. But I guess I'll go get a paper saying that it's closed and finalized. There's nothing's going on there.
Okay. Court is where you dropped off.
I turned it into the
Dropped off a copy
FOC.
of drug test results. I don't see any CPS reports. As long as the front of the court has those, the court will rely upon the front of the court.
Okay. Yeah,
well,
friend of
you
the
dropped
court.
off the-
Catherine Scott has them from friend of the court.
All right, okay, as long as she has those. All right. So the recommendation says that we think they're closed. If we can get documentation to verify that, that would be great. And then there's no question. So
And then I'd
basically
just like to have all my time. I mean, these reviews, we've been in this for a year long now, Your Honor. I'd like to get back to parenting with my kids and get back to my kids. I feel like I've done all that's asked of me by the courts, and I've done with all my due diligence to get my kids back into my household.
Okay, this seems to be, the court agrees, it's just been going on for about a year, and this has been very slow, but it appears that at least we're just slowly expanding parenting time. At least for now, you got unsupervised parenting time every Saturday and Sunday from 10 to 7 p.m. and Sundays noon to 4.
I understand.
For
I'm
months,
used to
we're
having them
basically-
Friday through Monday, so it's
Hey, can I just finish, sir? You're asking
Yes,
for
sir.
overnights, is that correct? You want overnights restored?
Yes.
All right. Ms. Nemec, why is your client opposed to overnights? I mean, Mr. Puget has done everything the court has asked. He submitted to mental health evaluation. He submitted to a drug screen that was negative. What else? What needs to be done in order to have the children with him overnight?
Your Honor, the drug screen was not observed. If you'll recall that the order of the court, the last time we appeared was that the drug screen was to be monitored. Mr. Puget did not engage in monitored, supervised drug testing. Ms. Sharp, throughout her relationship with Mr. Puget, saw Mr. Puget basically fake multiple drug tests throughout their relationship, which is why she requested that it be monitored. The children have said that Mr. Puget is smoking marijuana in their presence during their parenting time. If you will recall, the original allegations back a year ago were quite disturbing, causing or requiring the children to engage in exercise until they threw up, the youngest child having to plank until he vomited, and then being
Court calls that.
Wow.
Yep.
Yes.
There's extreme discipline imposed by father.
correct.
Hopefully father now understands that now, but he seems to be addressing those issues.
Mr.
Obviously, the
Puget,
oldest child is 14. What the 14-year-old
The
child
oldest
know if
child's
dad's
gonna be
intoxicated or high?
15. Sorry.
I'm sorry, Your Honor, I couldn't hear you because Mr. Puget spoke over you.
Okay, the oldest children are 14 and 12. Mr. Peugeot said, the corrected court said the oldest one is 15. Want the 15-year-old know if dad is high or intoxicated during parenting time?
They
Yes.
have said as much, which is why we asked for the drug testing. Since the last time they took pictures of drug paraphernalia lying around the house. Unfortunately, the minor child Alexis's phone was dumped in a lake in the interim, and so we don't have that picture. But Alexis, who is the middle child, is engaging in some concerning behaviors. It's just come to Ms. Sharp's attention that Alexis is cutting. And they are working on getting her into therapy right now. She has some appointments scheduled today, but it's Ms. Sharp's position that if the children are forced to engage in additional parenting time, there are going to be negative responses from them. The children don't feel safe. That's why this family contract is in place. Mr. Puget, I'm speaking. The children do not feel safe. The family contract, one of the terms of the family contract was that Mr. Puget was not to have marijuana around the house, smoking marijuana in their presence or during parenting time. And according to the children, he has engaged in that behavior. Every time we come to court, Mr. Puget calls his children liars. Despite the fact he called them liars about the extreme punishments that he was enforcing. And they took video in order to prove that they were not lying. These children aren't lying about what Mr. Puget does. And yes, it's been a year, but I would submit that the reason that this behavior hasn't continued is simply because he hasn't had the opportunity to continue it. Ms. Sharp understands that we are incrementally increasing the parenting time, but she wants to do it in a way that is safe for the children. We're going from Saturdays now to Saturdays and Sundays. But it would not be safe, especially for Alexis, to just throw them into overnights at this juncture. In addition, I am not sure that any criminal investigation coming out of Dearborn Heights is closed. The CPS investigation was closed, but it was closed because the children were not in Mr. Puget's custody. That is why CPS closed the case. But as far, Mr. Puget, I'm not done. As far as the criminal investigation, I haven't spoken to Detective Derwick in a while, and it's because the last time that I did, he set the expectation that Wayne County is so backlogged that I couldn't expect a charging decision for nearly a year, was what Derwick told me.
I'd like to speak if I could, Your Honor.
Okay, well, yeah, just let Ms. Nemec finish. So she's finished, so you can speak now, Mr. Puget.
I'd like to say that a lot of this stuff that's being said about me is a lot of defamation and hearsay. Miss Sharp saying she's seen me pass drug tests when we were together. You know, she's with a recovering heroin addict right now, and they're worried about my marijuana use, which I've proven that isn't going on. Miss Nemec says the kids don't feel safe. My daughter's cutting herself in her mom's household under her house. I haven't been around. I feel like a lot of the problems are being set up for me to be the bad guy, and I don't understand how this is arising when I'm not even in the picture. I'm just on Sundays. You know, my daughter was approached by boys at school and forced into a corner, and Miss Sharp didn't know about that, like she doesn't know about this. It's not that my daughter is worried about being safe for me. My daughter is just going through being a teenager. She's going to be 13 in a couple weeks. My youngest son's going to be 11, and my oldest son's going to be 15 this year. These kids are all getting older. They know right from wrong. And with the smoking stuff, like, I'm not smoking in front of these kids. They're free to use their phones. And if they had anything that they had, they could have produced a picture or some type of video to the court today, which isn't here. So like I said, this is just constant reflection of Miss Nemec's hearsay that she brings in the courtroom, and she doesn't really have any evidence to stand on. All the cases against me are closing. The CPS is closed. Dearborn Heights, they have their own prosecutor here. They could have took me to court here, but they sent it downtown to Wayne County to get shot down because there's not enough evidence and they knew that it would fall flat, which I'll get more information on that and turn it to the courts, proving that there's nothing there either. And then for them to say that I got off the CPS case because they're not in my presence. I went to the CPS place on Joy and Greenfield at least 5 to 7 times to conflict their motion and their opinions on me. And a lady sent a thing to Laura, which got me taken off the list. It wasn't nothing about that. The thing it was me constantly putting my effort toward proving myself innocent in all this, which I feel like I have since the beginning. You know, in the beginning of this, it was I abused the kids and I was mentally unstable. And then now it reverted back to I use marijuana, which is recreationally approved by the legislation in the state. And Miss Nemec, you know, she's constantly she's always just kind of just putting a lot of defamation on me, hearsay, things that can't really be proven, things that might be or could be, but there is no definite yes or no behind it.
And Ms. Nemec, did the last order of the court, Mr. Puget was granted unsupervised parenting time on Saturdays and Sundays if the drug test came back negative. The drug test did come back negative, but he never was granted that parenting time. Is that correct? Because it was supposedly not a supervised test.
Correct, Your Honor. If you'll look at the second part in the notes, and we
I
discussed
see. Yes,
on
yes.
the record,
That's
the dress was
okay. I understand it was to be supervised, but how do you know it was unsupervised?
because I spoke with Concentra repeatedly. In addition, I sent them a subpoena. They responded with a copy of the test. I believe that you have a copy of it, and if you'll see in
Yes.
step 2, if you look in step 2, there are 2 boxes, one of which is observed. It is not marked. I also personally spoke with the manager at the location. She let us know that they actually don't do any type of observed testing. If he is to engage in observed testing, he would have to go to Quest Diagnostics instead of going to Concentra.
Yes, but over the phone, Miss Nemec was given the information by Concentra that they would do it. Josh Walker was in the presence, and I followed all details given to me by Miss Nemec and in that court order to take that drug test. I went to the Southfield place at the exact time, and I also had an email from Miss Nemec explaining all those directions. I followed the directions to detail. It wasn't my fault that Concentra didn't go through with those when I got to the place. That's all that I would like to say about that statement. And then for her to say she knows it wasn't unsupervised, she wasn't there. It's heat administered. It's not. It has to be a certain temperature. All types of things. I think it's a defamation of her to just constantly keep saying she knows I faked the drug test.
Mr. Peugeot.
Yeah.
Was your urine screen, was it supervised?
It was not because the Concentra. No, it was not supervised. Your Honor.
Okay. All right. Okay. Hold on right there. The recommendation today is that parent time is going to start this Saturday, 10 to 7, and Sunday, noon to 4. This coming weekend, it's going to start, and there's no condition. So you have the parenting time. It's not conditioned upon you submitting to another drug screen or anything. There's no conditions.
Okay.
You will have the children, hold on, the children will be in your home every Saturday and Sunday. We're going to come back in a month. And the intent of the court, unless there's issues, it's intent of the court to go back to overnights at that time, Mr. Peugeot. So I understand you've tried your hardest to comply with all orders of court, and I believe you have. But that's just the children to put them right into overnight, and they've been have not had that in perhaps a year or so. We're going to start slowly, so there'll be no conditions. You'll have the children in your home 10 to 7 this Saturday and noon to 4 on Sunday. Try to plan something fun for the kids. Do a cookout.
I've been taking them a lot of things.
Okay. Well, it's always been therapeutic as the court recalls, but the court's going to adopt the recommendation. I fully understand your position, Mr. Puget, and yes, it's the open intent of the court. Unless something happens between now and July 19th, it is the intent of the court to allow overnight parenting time, and with certain conditions, no marijuana use, no imposition of punishing activities for the children, no corporal punishment. Now, I do know you subpoenaed a Christie team from Family Council Child Services this morning. Mr. Walker, did you talk with this person from Family Council Child Services?
No, they didn't let nobody in.
Mr. Peugeot, let some other people talk, please. maybe you need to listen to your children, give them a time to talk to you rather than just you controlling the conversation. Mr. Walker, did you have a chance to talk with this witness this morning?
I did not, Your Honor.
Okay. What is the intent of this witness? She's going to probably say everything has gone well with supervised therapeutic parenting time. Is that correct, Mr. Bouger? I'm assuming that her testimony will be positive.
Yeah, the testimony was heard because Miss Nemec was constantly undermining all the things and saying that I won everybody over at Family Shelter Services and that you know that the family agreements plan wasn't supposed to be used as a weapon, but as a tool for us to get back together and being a family.
Well, sure, it's a tool. It's not a weapon. And obviously, if there were concerns on the department's team, she would have related that to the front of the court. And obviously, there's no concern that she's related to Mr. Walker, the front of the court. So I don't believe we need her. I don't think her testimony will serve any purpose this morning. I appreciate you going the extra step and having her subpoenaed. You also subpoenaed another witness by the name of Sierra Peugeot. And who is Sierra?
She is my sister. She's present during all the meetings where the kids are saying I'm smoking and things like that. I brought her in here to kind of say that none of that was going on and that the kids are safe. I take them to go-karts, bowling. I let them eat whatever they want. There's nothing unsafe over here. And I just don't have anybody reporting actual facts. So I wanted to have another person besides myself say what they see at the visits.
The court's going to give you the benefit of the doubt and assume that your household is safe for the children, Mr. Bouger. And again, absent some issues that arise or problems that arise between now and July 19th, it is the intent of the court to expand parenting time to go back to what we had before, to some overnight parenting time. But the court at this point in time will adopt this recommendation. I realize you're getting it's been a long time, but at least you're going to have, without any conditions, you're going to have unsupervised parenting time. The children will be at your home on Saturday and Sunday. The only thing we need to talk about is transportation. Ms. Nemec, was that discussed at all, Mr. Walker, about who's going to pick up, who's going to drop off?
No, we did not discuss that. I believe that the parties have been handling transportation. Ms. Sharp, how has transportation been handled since the Sundays were instituted?
We split it. He picks them up in the morning. I pick them up in the evening.
Okay.
All right.
So a traditional.
So that will continue, Mr. Bouger. That will continue at any time that you've worked out in the past. So again, it'll be this Saturday from 10 o'clock to 7 and the Sunday from noon to 4. So every weekend between now and July 19th, we'll come back July 19th to review everything.
Okay. And Your Honor, can I also have it to where the pickup position is at her house and not anywhere else crazy?
That's appropriate. Ms. Nemec, any reason why it can't be picked up at the at mom's house?
Amanda, I'll let you address that. I saw the look on your face, so go.
It's because up to this point, they've always been picked up from my house. It's just that we have our yearly camping trip that we were trying to plan, but it does go over his days. And I asked him if he would be able to pick them up from the campground, which is in Jackson, and drop them back off, since he won't allow them to, he won't switch days with me.
I offered you one Saturday overnight for you to have that whole vacation with 2 of my weekends, and you wouldn't meet me in the middle.
I just was willing to give you the same amount of time during the day on a weekday or whatever day worked best for you.
Well, the best schedule is when the two of you communicate and work out together, make it good for both you and the children. But if you cannot agree, this is what's going to happen. If you cannot agree as parents, you know what's best for your 3 children. But if you can't agree, you're asking a total stranger like the court to make the decision, and the court's going to adopt its recommendation. So every Saturday and Sunday, and you'll pick up at each other's home, pick up and drop off each other's home, unless you agree otherwise. And it makes sense to communicate and be flexible. It's summertime. If kids like to camp and you got a camping trip planned, try to make it work for the kids. So the two of you should talk. You're your parents. In any event, we'll conclude this matter. Court will adopt the recommendation. We'll see everyone back on July 19th at 2 o'clock.
Thank you, Your Honor.
All right. Don't know clip time. That was a serious one. I told you. 0 to 100. Quick. That was a good one. All right, here we go. Don't know, brought to you by Monkey, Mark, Daylight, and Monica. Thanks for the donos and the memberships. Let's get it going. I'm not kidding. This man's name is Mr. Frog. Frogg.
Questions?
Okay, all right. Mr.
Mr.
Delaney, you'll be
Frog.
released today.
Here we go.
You're welcome. So just get that set for the trial calendar. Yeah, because today is day number 1 on a 90-day clock. Okay, sure. And in Nisqually Jail, your name?
Adam, you talking to me?
Is it Mr. Farag?
Mr. Nabil Farag, Your Honor.
Very, thank you. All right. And you're here on several warrants. We got City of Tumwater.
She calls him Frog. Mr. Frog.
And State of Washington. And 1 second, I'm going to talk to my clerk. There's another one that we didn't get to the calendar. Okay. It goes all the way back to February 22 of 21. Here's the cause number.
Judge Ellen. Judge Sniffles.
Oh, all right. So we got several. And Mr. Stillwell, have you had a chance to talk with Mr. Farag about all of these?
I have, Your Honor, and I believe to begin, probable cause has been established on all of them. And so I've had an opportunity to speak with Mr. Farag about his constitutional rights. I believe he understands them. No need to deal with probable cause. We'd like to enter a plea of not guilty on each of these. I believe each case before the court this morning is an arraignment.
Well, most of them are.
Most of them.
Some are pretrial, or still pending trial, I should say.
Okay.
Your Honor, the attorney.
Mr. Farag, let me hear from Mr. Stillwell, and then I'll turn, one person at a time here.
He's not.
And Mr. Still.
He's not entirely my attorney.
Well, he's here from Thurston County Public Defense, gratis of the county, to help you today.
I know, I appreciate the help and, but I mean, we need to seriously consider my custody status because I've got a lot.
That's what we're talking about, Mr. Farag. That's exactly what we're going to get to today.
I got 3 purebred German Shepherds in the house alone, and they're never been left that long. And I don't have anybody to take care of them. Luckily, today is not as hot as it was yesterday. They were fed before I left, dry food. They usually get better food than that. And they're the water and my house
So,
is
Mr.
not locked.
Farag,
It
let
was
me
not
get
secure.
back to that. I have to deal with some logistics first,
this
and then
real?
we will talk about all that. But let me hear from Mr. Stillwell without interruption at this stage. So,
Thank you.
Mr. Stillwell?
Thank you, Your Honor. So we would like to enter pleas of not guilty on the matters before which there's arraignments this morning. I do understand some of these matters were failures to appear. I believe those were for arraignments for all except for perhaps one.
Lisa.
The matter ending in 393, which is the last one on the calendar list.
So we'll continue not guilty pleas on those that were entered, I take it.
Yes, Your Honor.
Okay, and then accept not guilty pleas to, let's see, disorderly conduct, criminal trespass, 1, 2, 3, 4, 5, 6 counts of violation of protection order or some kind of order restraining.
Like
malmish, 2 counts of malmish, and 1, 2, 3, 4 counts of driving while suspended third, and 1 reckless driving. Will continue that not guilty plea.
Mr. Frog is a thug, savage. He is savage, running shit out in Thurston. Do you see that rap sheet? Oh my God. And he's bitching about his German Shepherds? Oh my God. He's lucky he's not locked up for 20 years. DeSantos locked guys up for 6 months for less than that. Jesus Christ, Frog. Get your shit straight.
And proceed on to a pretrial conference. So going forward after today, Mr. Farag, would you like the court to appoint Thurston County Public Defense?
He looks like a poor man's most interesting guy in the world.
To represent you?
It all hinges on whether I get PR'd or not, Your Judge. I want to stay in close contact with the court now that we have broken the ice as far as appearing before the court. There was
So answer my
Wait, he calls the 4, 5 warrants breaking the ice. Now that we've broke the ice, like he played a name game with HR. Now that we've broke the ice, Your Honor, let's take care of this. Let's get on the brass tacks here. Oh my
Question,
God,
if you
I
would,
can't.
Mr. Farag.
No, I don't want an attorney, I don't want an
appointed?
attorney to supersede me and supplant me and silence me. He doesn't know
Okay,
any
so you
of the
want to,
facts.
so you want to represent yourself after today, is what you're telling me.
Well, yeah, but today is far more critical. It's gonna have a bearing on what happens after today.
All
Because.
right, well, maybe
uh,
we'll revisit that. All right, so.
A fair
let me hear from
trial,
the
all hinges
prosecuting
on what
attorney.
happens today.
Let me hear from the prosecuting attorney and then we'll turn back. So Mr. Farrow, on behalf of the city and the county, what are you asking of the court on release conditions?
Well, Your Honor, as the court's aware, Mr. Farag, I think, has 13 active warrants, as well as a very lengthy criminal history.
13 active warrants. I spoke out of turn. I thought it was 5. 13. And he cares about his dogs and breaking the ice. No lawyer. I'm good.
However, looks like I think all of these matters are from 2022. And it looks like most of the warrants were issued within a 2-month span. I've read through as many of the police reports as I had time to, and just, I mean, quite honestly, I'm not sure what's appropriate here, Your Honor. Doesn't seem like there's violence in any of these charges. It's mostly just the sheer number of them.
It's just a pain in the ass.
I hate to do this. I think the state's going to defer to the court as to release conditions on, or as to what to do with the warrant on these cases.
Broke the ice.
So, Mr. Stillwell?
Thank you, Your Honor. In speaking with Mr. Farag, the failures to appear seem to have been stemmed from his inability to attend court in person and his sort of lack of technological ability to attend via Zoom previously. He does now have smartphone capability. We discussed the fact that he could attend if out of custody over Zoom for certain hearings. We have good contact information for him. And so considering, sort of acknowledging the number of cases however, pointing out the sort of the lack of violence here in the criminal history and the warrants being issued for sort of failures to appear, as was indicated, within a reasonably narrow amount of time. We'd ask for him to be released on his own recognizance. I'd be happy to chat the phone number for Mr. Farag's smartphone to the court so they have it. So he gets text reminders and is perhaps able to attend via Zoom when
They
he's
already
able to
have
do
it,
that.
attorney. They've sent me text messages.
Right, and Mr. Farag was back at the front counter of the court all the way back August of 2022. We gave him a court date and he didn't appear again to clear up those, and then there were new law violations. So
September 22, there hasn't been any new violations, Your Honor, in the last year, whether it be traffic or the non-traffic, the anti-harassment case. It all has to do with the neighbors next door, and they've given me difficulty. Safety.
So
and
why
security.
didn't you come back to court? You came to the front counter to clear up those warrants. We gave you a court date and you didn't come back. And then you contacted us.
Well, I know
contacted
September
us, and you
9th,
didn't
I
come back.
dislocated my thumb. I wouldn't have been able to write in court. I'm right-handed.
A dislocated thumb. There it is. Excuse of the week.
And then I've had 2 dogs, 2 purebred German Shepherds that cost me $3,000 combined. And they have me restricted. I can't move. I couldn't bring them in the courtroom. And then right now, I have to be careful where I take them, where they sit, because if they go poo-poo or pee-pee, they're gonna make a mess. And I ended up foolishly getting a 3rd dog, 10 and a half.
If they go poop or pee pee, I have a dislocated thumb. How am I going to pick it up?
half weeks old chocolate lab cost me $900 last Sunday.
Look at this. Look at this. Watch the attorney. Watch the prosecutor. Ready?
Not this Sunday, this bullshit getting a third dog, 10 and a half weeks old chocolate lab cost me $900 last week.
He's definitely trying not to laugh.
Last Sunday, not this Sunday, the Sunday before. So it's going on 8 days. But I want the court to work with me. I want you to consider my rights because the neighbors have been pushing me around. It's been going on 5 years. It has had a dramatic effect on me. And I just wonder, their hands are not clean, Your Honor. So these charges that have to do with the neighbors at the dual buildings, they are subject to mitigation. I want to explain this. I'm going to file a civil lawsuit.
What?
But my house has been damaged. I've got roof damage that has resulted in 5, 6, 7, 8 years later, a hole in a big, large bathroom. And mildew has crossed the phone. That's where my computer is, my main computer. With Windows 7, I think, and it's got my other computer at the other end of the house. The Windows 7 went on the blink, and those computers are not. They don't have the they don't have the Word software, Microsoft. And so I'm struggling with a lot of difficulties and restrictions. The dogs, the
So,
house,
Mr. Frog,
damage,
and I start a job tomorrow.
the court has to make a decision here, and we've issued at least 5 warrants on one of these matters to get you back into court. Let's go back.
I want to start fresh.
Don't interrupt me, Mr. Frog. I'm ruling. This goes back to
I wanna start
2021, not being able to come into court. We've continued things. We've allowed you warrant quash hearings. You
Your
haven't
Honor,
come
we
in.
had
You
to
haven't
see
come
how-
in. I'm asking you not to interrupt me, Mr. Frog. So at this stage, we have not been able to get anywhere with your cases because of you. I'm going to have you post 500 cash or bond on each matter. And there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 matters to ensure that you come back. And I'm appointing Thurston County Public Defense. Now you'll tell us once you meet if you want their assistance or not, but I want you to have that opportunity and then to make a decision about that once you talk to them. But these cases carry some significant significance to you. So we'll have a pretrial conference. If you post bond on all of these, then you bring yourself into court or you come by Zoom. And I'm going to set that hearing for June 30th at 10 in the morning. If you're still in custody, we'll have a hearing at 1:30 in the afternoon, and you'll have benefit of having time to talk to an attorney. But in the meantime, you don't drive, you don't violate the law, you don't violate no contact orders, and you come back to court.
Oh, come on. This was fantastic. I'm about to cry.
So that's it for today.
Oh. That was unbelievable. Mr. Frog. Clip of the year.
Questions?
Oh, it's been fun, guys. Oh, another beautiful live. I thank you. Thank you for all who sponsored that wonderful clip. Oh my God, I gotta compose myself for that one. That was great. All right, guys, thank you so much. I don't think Kitch is live tonight. Haven't seen her. She's probably busy. So have a good night. Sleep tight. Don't let the frogs poo-poo and pee-pee all over your dislocated thumb. I am Time, and you have been served.